will soon make it clear they don't understand you. You know, you're on social media now. What? Don't understand. What a load of rubbish. So then you've got to think again and try to express yourself more clearly. Okay? So no questions, queries, worries, anxieties, comments, suggestions? You know my suggestion, make sure you know the must-know principles, definitions, case names, yes, and a little bit of legislation. Section 16 of SOGO, I would suggest must know, okay, it is legislation and it's a closed book exam, but if you can work it into an exam question, you'll get extra credit. Okay, so before the break, we're talking about terms and the classification of terms. Wallace and Pratt must-know case because it gives us the general classification into warranties and conditions. But it doesn't give us innominate terms. The innominate or intermediate term comes from the Hong Kong fur shipping case, must-know. So it's a local case. I mean, Hong Kong fur used to have ships anchored in Hong Kong harbour, which used to sail to the Middle East and used to transport cattle there. All right, and one of their ships, I forget the name of the ship, but was involved in this particular case, and there was a term in the contract which says that the ship would be in every way fitted for ordinary cargo service. In every way fitted for ordinary cargo service. Now, what on earth does that mean? Good question. The courts couldn't classify that as a condition or a warranty. So they had to look at the effect of the breach. Was the innocent party deprived of substantially the whole benefit of the contract? The court said no, the ship could still sail, it was still seaworthy. Okay? And in a similar case of, in fact, I've got these cases here, here's them there. Where is it? I haven't got the one, I haven't got the yes, Yaman Singh. Yaman Singh is the other case in which the court couldn't classify a term as either a condition or warranty, and in Yaman Singh and the International Trade Corporation, the clause says that the goods were to be, quote, shipped promptly, unquote. Shipped promptly. What on earth does that mean? The courts couldn't decide. Was that a condition or a warranty? So they looked at the effect of the breach and found that the innocent party was not deprived of substantially the whole benefit. Okay. So they classified it as basically breach of a warranty. Okay, so know the test, and the important wording is actually in the earlier PowerPoint. Is the innocent party, the other party, deprived of substantially the whole benefit of the contract? And I emphasize the word substantially because in Wallace and Pratt, the court said a condition is one in which the other party is, the word substantial came up 3 times, okay, describing what a condition is. Okay, so I think they're the must-know cases. Wallace and Pratt, Hong Kong fur, they're your must-know cases. The other case is sort of interesting. Schuler and Wickman. Now, how does the court know whether a term is a condition or a warranty? Well, they'll look for the intentions of the parties. How do you know the intentions of anybody? From the words they use. Okay? So, Angela, what do you intend to do after class tonight? Go home and study contract law. Good girl. So, how do we know what Angela's intention is? From the words she uses. And that's it. And that's how the courts decide whether a term is a condition or warranty. Look at the words used. And if it's clear, you follow the wording. Now, in Schuler and Wickman, there was a term which was described as a condition, and there was breach, but it was a clause saying that one of the parties had to visit the other party's factory once a week over a number of years. They missed one visit out of 1,400. So the other party sued for breach of a condition. And the court said, no, this was not a condition, even though it was described as a condition, because the court said they're using the word condition in a non-legal, non-technical sense. Okay, but query that. I mean, if condition is a condition. So you've got other cases which go the other way. Oh, rice in your mouth's always a good one. So there you are, you people eating illegally in classroom. Rice in your mouth. In rice in your mouth, the contract said that every term was a condition. The court said this doesn't make commercial sense. So they had to interpret the wording of that particular contract themselves. Okay. So how do you know whether a term is a condition or not? Well, the courts look for the intentions of the parties, so they examine the wording, and if it's clear, they follow the wording unless it leads to exceptional or extreme consequences as in Schuler, or is contrary to commercial sense as in the Rice case. So words matter. That's what it really boils down to. And that's all you need to worry about with regard to classification of terms. Wallace and Pratt gives us the general classification, conditions, warranties, and the Hong Kong Fur shipping case gives us innominate terms, and that's basically it. Okay, except perhaps what I've got at the bottom of the screen is quite useful as well. How do you know the intentions of anybody from the words they use? So if you want a term to be a condition, spell it out. Say, you know, breach of this term will entitle the innocent party to terminate the contract. Well, that's a condition. Or if you say a term is an essential part of the contract, that's a condition. Such as time shall be in every respect of the essence of the contract, that's a condition. And that's the Union Eagle and Golden Achievement case. Union Eagle and Golden Achievement, where have I got it? Actually, I may not have it. But in Union Eagle and Golden Achievement, which is in your case name, course manual, purchaser was just 10 minutes late in completing. Breach of a term, yes. Breach of a condition, yes. Could the innocent party terminate the contract? Yes. And claim damages? Yes. And the big issue actually in that case, well, what was the quantum of damages? We'll come to that a bit later. Okay, so that's terms. Anybody any questions about that? Now on to exemption clauses, which is still in the area of terms of a contract, but everybody make sure you know the definition. Must know. What is an exemption clause? It's a term in a contract which seeks to exclude or restrict liability for either breach of contract, misrepresentation, or negligence. Now that's not exactly what's on the screen, but when we say specified circumstances, we mean breach of contract, misrepresentation, or negligence. Okay? So where does an exemption clause fit in? It is raised as a defense to a claim for either breach, misrep, or negligence. So, excuse me just a minute. I did have my ice cream at the break, but my throat needs a bit of water. Okay, good. So everybody must know the definition of an exemption clause. Word perfect. An exemption or exclusion clause, same thing, is a clause in a contract. It's just one term, could be one term out of hundreds, but it's aiming to do a really big job. It's seeking to exclude or restrict liability for either breach of contract, misrepresentation, or negligence. Must know. Be aware of what a limitation clause is. It's the type of exemption clause just restricts liability. To what? Normally a sum of money. Okay. Also, watch out for wording. You could get an exemption clause question in Part B of the exam, and you could be given the wording of the exemption clause. Make sure you know an exemption clause when you see one. It may not say we will not be liable. It could say we will not be responsible, or we will carry no risk. That's still an exemption clause. Okay? So know the definition of an exemption clause, because then you can identify one when you see one. Okay? But know what it's trying to do. It's trying to act as a defense. So you could be sued for negligence, good, but you can raise an exemption clause as a defense. You could be sued for misrepresentation, but you raise an exemption clause as a defense. You could be sued for breach of contract, but you can raise the exemption clause as a defense. Know how it fits in. Okay, good. So let's not worry about that. Here's a good PowerPoint. If you get any question in the exam on exemption clauses, you've got 3 really good subheadings. Will an exemption clause be effective? Number 1, it will not be effective unless it's in the body of the contract. So your first heading is incorporation, because corpus means body. How do you incorporate an exemption clause into a contract? Either by signature or by notice. And the must-know case on signature, Lestrange and Grocott. Must know, must know, must know. So every time you sign a contract, you are bound by the terms in the contract, even though you haven't read it. Unless there's some form of fraud or misrepresentation. Must know, Lestrange and Grocott. Don't worry about Tilden. Tilden is one of these cases in which there was sort of misrepresentation of the terms of a contract. Okay, it's Lestrange and Grocott, which absolutely must know. Okay, so that's your first heading. Is the exemption clause? Well, the general question is the exemption clause effective as a defence? Well, only if it's in the contract, either by signature or notice. With regard to notice, the only must-know case on notice is Parker and Southeast Railway. That's your only must-know case, because Parker gives us the general test. Did the party relying on the exemption clause take reasonable steps to bring it to the attention of the other party? Well, that depends on the facts of each case. Chappleton and Barry, it's the guy sitting on a deck chair, fell off the deck chair, suffered an injury, sued the company. The company said, no, 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 look at your receipt. There's an exemption clause on your receipt. The court said, no, not sufficient notice. You don't expect to find an exemption clause on a receipt. So you didn't take reasonable steps to bring it to the attention of the other party. Okay? Right. So the other cases are just illustrations, though, of the general principle. Parker and Southeast Railway, that's your only must-know case. Did the party relying on the exemption clause take reasonable steps to bring it to the attention of the other party? And what is reasonable depends on the circumstances. Oh, this is pretty good. This is pretty good. Yeah, in red, no eating, drinking, no smoking, of course, and no mobile phones. Wi-Fi. Hello. But a notice has to be noticed, otherwise it's not a very good notice. Okay. Good. So don't worry about any of the other cases. It's just Parker and Southeast Railway. That's the only case. That's the test. What are reasonable steps does depend on the facts of each case. Don't need to worry about the level of court for Parker. Okay. Cooperation by notice, again, they're just illustrative cases. Interpretation construction, that's your second subheading. With the general issue, is the exemption clause effective? Well, only if the wording covers what you're trying to exempt liability for. That depends on the actual words used. But the must-know case here, everybody, is only one must-know case, really. Ailsa Craig and Malvern Fishing. is your only must-know case on interpretation. Unfortunately, not in your course manual for some reason. It should be. It was decided, and it's a House of Lords decision, so worth remembering, House of Lords. It was decided 6 years after legislation was enacted in England. Before the legislation, the courts were very, very strict on interpreting exemption clauses, such as in a case like Houghton and Trafalgar. If you've got 6 people in a car built for 5, is that overloading? No, it's overcrowding. Okay, but now the courts, because we have this extra layer of protection, namely legislation, the courts don't have to interpret the wording so strictly. So Ailsa Craig is a good case because it says the courts will not strain the meaning of the words. Relevant words must be given their plain, natural meaning. Okay? And the contra proferentum rule you should remember. The contra proferentum rule. Have I got it? Yeah, the contra proferentum rule, you should know what it means. Contra means against the offerer. If you're relying on an exemption clause, if there's any ambiguity in the wording, it will be construed against you. Contra proferentum. Okay. But again, not so important now because we've got Ailsa Craig. The courts will not strain the meaning of the exemption clause. Relevant words must be given their plain, natural meaning. Should know, not much. The Yingwai and Nanyang Credit Card Company one, it was a local case dealing with a crane, and there was actually an exemption clause, but the wording wasn't very elegant. The court said, doesn't matter. We will give the wording their plain, natural meaning. And that was it. Okay. So that's Ailsa Craig, Melbourne Fishing, your really only must-know case on interpretation. And then we get on to, I'll forget about this is history. And don't worry about that either. Legislation must know, this is the third layer of consumer protection. This is your third subheading in any question dealing with exemption clauses. And if the legislation applies, the Control of Exemption Clauses Ordinance, it renders an exemption clause either totally void or subject to the reasonableness test. Must know. Okay? It renders an exemption clause either totally void or subject to the reasonableness test. Now, the only must know section, I would say, of the CECO, and of course it's a closed book exam, so how are you supposed to remember legislation? Well, section 2 is important. It defines key words, and section 3 deals with the reasonableness test plus schedule 2. But I would say section 7 sub 1 is a good one. The reasonableness test, everybody, is very vague because the courts will look to see, is the clause fair and reasonable in all the circumstances? Well, that's very vague wording, so it's really up to the judge in a particular case. Important to note, I suppose, subsection 6 of section 3 is that the burden of proof is on the supplier, and that's an important point to make. But I would say section 7, I would remember, I would say this is a must-know, because if you want to illustrate the operation of the CECO, section 7 is a good one. Section 7 sub 1 says you cannot exempt liability for negligence causing death or personal injury, full stop. In other words, the clause is void. But section 7 sub 2 says you can exempt liability for negligence causing other damage, but only if it is reasonable. Okay? So section 7 is a good illustration of how the CECO works in general. It renders either an exemption clause totally void, section 7 sub 1, or makes it subject to the test of reasonableness, section 7 sub 2. Okay, good. So that's about it for the CECO, all right? Don't worry about that. Don't worry about that. And I throw in Socito. This would be, if you get a question in the exam on implied terms, it would be worthwhile writing a few lines on Socito, because the supply of services implied terms ordinance implies terms into contracts for provision of services. And again, it's not a memory test, but you can just say it implies terms that the work be carried out with reasonable care and skill at a reasonable price and within a reasonable time. By the way, all of those terms are conditions. Okay? And so, breach of a condition entitles the innocent party to terminate the contract and claim damages. Very important. Okay. All right, so that's it on the terms of the contract. Anybody, any questions? Okay. Probably the best way of summarising in exemption clauses is going back here. There's your good summary. But everybody must know the definition. And then must know, will it be effective as a defence? Good question. Well, it's got to pass the three tests. Incorporation, signature, Lestrange and Grawcott. Notice, Parker and South East Railway. Interpretation, Ailsa Craig and Morgan Fishing, House of Lords. Okay? And remember, the courts are not so strict on interpreting the wording now after the legislation. And then the legislation itself, the CECO, renders an exemption clause either totally void or subject to the reasonableness test. That's it. And I'd say section 7 sub 1 is a good case to cite. Okay. All right, so any questions about that? Right, let's move on to the Vc18 Elements. So there they are. Misrepresentation, must know. Mistake, might like to know. Duress, must know, particularly economic duress. Undue influence, must know. Unconscionability, must know. Illegality, might like to know. And make sure you know what voidable means. The contract is terminable at the option of the innocent party. If the innocent party does nothing, the contract carries on. So that's an important point to make. And remember, it's important to know whether the contract's alive or dead. No such thing as a walking dead contract. You're either alive or you're dead. Let me think. Alive. Nobody's sleeping yet. Pretty good, well done. I mean, that seems like it's 7th or 10th series, isn't it? 10th season, The Walking Dead. And I like one of the theme tunes. I mean, did I play any music on my online lessons with you lot? I didn't. I like playing music. There's a good song called Driver's Seat. That's from The Walking Dead. Anyway. Okay, so let's go through these quickly. Misrepresentation, probably the most important one, because it can come up in either Part A or Part B as a full question. So, number one, make sure you know the definition. You know what it is. A false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. Must know, word perfect. So, if you are alleging misrepresentation, you've got to prove all the elements of misrepresentation. Good. And what else? you have to state what type of misrep you are going to claim. Right? Let's quickly go through, and there are three types of misrep. What type of misrep would you advise your client to claim? You've got a choice, one of three. Well, oh my goodness. I know it's getting late. Well, let's have hands up. Who would advise your client to claim fraudulent misrep? Innocent misrep? Okay, there you go. One.
No, I told you that you go to the second one.
Okay. So what type of misrep would you advise your client to claim? Who says negligent misrep? Good, well done. Why? Well, you know why we're coming up to it. Okay, so first of all, of course, you've got to prove the elements of misrep, and with regard to that, remember, with regard to statement of fact or opinion, it's Bissett and Wilkinson, contrast Smith and Langdon House. Smith and Langdon House is in your course manual, covered pretty well. A statement by the existing landlord about the sitting tenant was held to be a statement of fact because the new landlord who was buying the property didn't know the tenant at all. The existing landlord said, oh, he's the most desirable tenant. He was not a most desirable tenant. So that was a false statement of fact. What's the difference? The courts will look at the relative knowledge of the two parties. If one party has expert knowledge or experience, a statement by him will be treated as a statement of fact. But if the parties have equal knowledge, a statement by one will be treated as a statement of opinion. And that's Bissett and Wilkinson, not in your course manual. Should be. It's in just about every other contract book. Bissett and Wilkinson, it was a statement about the carrying capacity of a farm in New Zealand. How many sheep would it support? Nobody knew. So a statement by one party was treated as a statement of opinion. Okay. And then with regard to induced, the only must-know cases is silence a misrep. With the no Flanagan, should know, bordering on must know. With the no Flanagan is a case in which a statement was made, which at the time was true, but then circumstances rendered that statement false before entering into the contract. In that case, silence would be a misrepresentation. You have to speak up. Okay? And with regard to being induced, probably the most important case is Edgington Fitzmaurice. It need only be one reason for entering into the contract. I've got a new PowerPoint on induced here, so you might want to take a photo. How does the court decide whether the representee was induced? Well, he will not be induced if he's unaware of the statement or ignores or knows it's false and decides the contract anyway. So he's obviously not affected, he's not induced. Now, if a reasonable person would have been induced, then the burden of proof is on the representor to prove otherwise. On the other hand, if a reasonable person would be not induced, then the burden of proof is on the representee to prove he was induced. And that's a fairly recent Hong Kong case called Master Yield and Co. Okay? In the Mussupreme case, a reasonable person would not have been induced by that statement, but the representee was able to adduce evidence that he was actually induced. So, slightly tricky on whether the representee has been induced. It depends on whether a reasonable person would have been induced or not. Okay? So you might want to take a photo of that one. Okay? In an examination question, use your magic two-letter word. If the representee was induced, then obviously misread. Okay? So that's the way to do it. No need to go into great detailed analysis on that issue, but as long as you raise the point that the representee's got to prove he was induced. Okay. All right. And then moving on to the remedies. Well, we don't need to go on to the remedies too much. We just need to go straight to the very important one. Must know, must know, must know, must know. 50% of all marks on misrepresentation are on the definition of misrepresentation and proving the elements of misrepresentation. But then, of course, the misrepresentee has to state what type of misrep he is claiming, and we all agree he should claim negligent misrep. Why? The answer's on the screen. The burden of proof is reversed and put on the representor because of two words he proves in section 3.1 of the misrep ordinance. I trust you have highlighted those two words in your course manual. He is the representor, so the burden of proof has been reversed. Secondly, it's a heavy burden of proof as shown by the Court of Appeal decision in Howard Marine and Ogden, not in your course manual. It should be. In Howard Marine and Ogden, a statement about the carrying capacity of a ship turned out to be false, but the representor said, I'm not negligent because I relied on the Lloyd's Register of Shipping. But the court said there were facts in that case which did lead to that statement being false, and so the court found he was negligent. And then finally, and most controversially, everybody, the fiction of fraud. The level of damages for negligent misrep is the same as for fraudulent misrep. This is because of the two words so liable in section 3.1 of the misrep ordinance. And again, I'll trust you've highlighted those two words. Okay. Now, this is very controversial because you're treating somebody as merely negligent as if they're dishonest. It's the fiction of fraud. But the courts, both in England and Hong Kong, the Hong Kong case is Pepsi Cola, Hong Kong Court of Appeal, Mr. Justice Con said, well, look at the wording of section 3.1, that's what it says. So you can criticise the wording of section 3.1, and indeed England's going to change their legislation sometime because they think it's wrong. And indeed, has this now tilted the balance too much in favour of the representee? Probably yes. Okay. So what's on the screen, everybody? 40 marks and 40% of any marks on misreps on the screen. What's the other 10%? 50% for writing down the elements of misrep and then analysing whether the representee, whether it's a statement of fact or opinion, and whether the representee has been induced. 40% for what's on the screen. And then the other 10% would be, well, if the representor is able to show he's not negligent, then he's innocent. Can the representee still get a remedy? Yes, the court can award damages, albeit on a lower scale, in place of rescission. What is rescission? Putting the parties back in the position they were before entering into the contract. But usually it doesn't work for rescission because there are bars to rescission, such as long delay, affirmation by the representee, or acquisition of rights in the property by a third party. So theoretically you can get rescission, but in practice you won't. And under the legislation, the courts can award damages in place of rescission. Okay. There's a very technical point here, though. If rescission is barred under section 3 sub 2, can the court still award damages? Well, some cases say yes, other cases say no. This is a very technical point. Thomas Witter said, well, we still get damages because the whole idea is to give a remedy to the representee. But the other cases, which the fancy name, floods of Queensberry, British Aerospace, say no, because the courts interpret the wording of section 3 sub 2, and they say, well, it looks like if rescission is barred, you cannot get damages. So this is a bit of a academic point. If you can mention this in the exam, you'll get an extra few marks, but don't worry too much about it. Okay? All right. So let's quickly go through this. Well, misrep again, must know the definition and apply it. And then remember, the representee has the burden of proving that a misrepresentation has occurred, but then you have to state what type of misrep to claim. Always advise them to claim negligent misrep. You know why. Okay, good. So any questions about misrep? Mistake, forget, you're not going to be examined on mistake, even though it's sort of interesting. Duress, should know physical duress. Obviously, if you hold a gun to somebody and get them to sign a contract, that's not being voluntary, and so the contract will be voidable at the option of the innocent party. Much more important, of course, is economic duress. It's, if you like, the modern form of duress. And remember, we covered this when we covered Williams and Roffey. What are the elements of economic duress? There must be a threat to do something illegal, such as be in breach of contract, plus no practical alternative for the other party, plus protest by the innocent party. How on is your case? Privy Council must know. And this element of protest has become much more important recently, because the courts have to distinguish between legitimate pressure, the rough and tumble of commercial dealing, which can be quite vigorous, but still legitimate, and illegitimate pressure. The main difference seems to be this element of protest. And how do you prove you protest? Well, you have a meeting with the other party, you take minutes of the meeting, he says he's going to be in breach of contract, ... I said I don't like it because we painted into a corner. I said I reserve all my legal rights. Bingo, that's good evidence you protest. Okay, good. So that's economic duress. Renders a contract voidable at the option of the innocent party. And then undue influence. Again, undue influence is the equitable counterpart of duress. Renders a contract voidable, again, at the option of the innocent party. If you get undue influence, it'll be only in part A of the exam. Could be a full 20-mark question. So what's on the screen, everybody? I'd say must know. Okay. There are two types of undue influence. The less important one is actual undue influence, where the burden of proof is on the weaker party that undue influence was actually exerted on him by the stronger party. The must-know case would be the BCCI and a Booty case, in which a young wife who's about 20 years younger than her husband signed a lot of documents. She didn't know what she was doing. The husband was a bully. Sign it. Sign it. Okay. So she sued for actual undue influence, and she was able to prove all the elements, but unfortunately one of the elements in 1990 was you had to show you entered into a transaction which was to your detriment. The exact words was to your manifest disadvantage, and she wasn't able to show it was to her manifest disadvantage. What do you mean by that? Well, why did you sign it? What's in it for you? Okay. The Pitt case, which came a bit later, said you don't have to show manifest disadvantage. All you have to show is you entered into a contract, but there was undue influence exerted on you. The problem is proving the undue influence, actual undue influence. So the more important type of undue influence, everybody, is, by a long shot, is presumed undue influence. And this depends on whether you're in a special relationship or other relationship. The Class 2A special relationship, doctor-patient, solicitor-client, parent-child. If you're in those relationships, the presumption of undue influence arises automatically, but it's only a presumption. It doesn't mean there's undue influence, because it's a rebuttable presumption. So if there's evidence to rebut it, such as the innocent party being given ILA, what's ILA? Independent legal advice, then that will rebut the presumption of undue influence, okay? Now, the second relationships are the so-called Class 2B, where you repose trust and confidence in the other person and then enter into a transaction that calls for an explanation. What do you mean by calls for an explanation? Not explained by the ordinary motives of ordinary people. So if you can establish those two elements in Class 2B, again the presumption arises. Doesn't mean there's undue influence though, because it can be rebutted if the weaker party is given independent legal advice. Okay? So what's on the screen, everybody? Must know. That's a good summary of the presumptions. Okay? And the must know case is Ettridge. Ettridge, House of Lords, must know House of Lords. Ettridge has clarified all the law on undue influence. Ettridge particularly presumed undue influence, and it's confirmed what we've just said. With undue influence, depends on the class of relationship. Class 2A, the presumption arises automatically. Class 2B only arises if the weaker party reposes trust and confidence in the other party, coupled with a transaction that calls for an explanation, not explained by the ordinary motives of ordinary people. Okay? But again, this is only presumption arising. Presumption can be rebutted by making sure the weaker party is given independent legal advice. Useful today, I'll say Li Xiao Ying and also Wong King Sing are should-know cases. In Li Xiao Ying, it was a Class 2B case. The weaker party did repose trust and confidence in the stronger party, but the court said did not enter into a transaction calling for an explanation. So in Li Xiao Ying, Court of Final Appeal, the presumption didn't even arise. Similarly in Wong King Sing, even worse, because two brothers, the court found there was no undue influence, no relationship of trust and confidence, because they were both university students, and so there wasn't one party reposing trust and confidence in the other. So it's a shame both these cases did not succeed in the claim for undue influence. Li Xiao Ying only got halfway to raising the presumption. Wong King Sing didn't even get halfway to raising the presumption, which is a shame. But Li Xiao Ying, the leading judgment was by Lord Scott, non-permanent judge. And he was one of the judges in the House of Lords in Ettridge. So Ettridge applies very clearly in Hong Kong. So Ettridge is your must-know case. Any question on undue influence must mention the House of Lords in Ettridge. Should mention Court of Final Appeal, Li Xiao Ying. Okay? Good. So anybody any questions about undue influence? Remember, it arises in equity out of the relationship between the parties. It's a more subtle form of pressure. Now, we're all in relationships, okay? So, are you the dominant party or the weaker party? Or is it equal? Well, good question. So when you go home tonight, turn the hello dear, are you the dominant party tonight? Oh, what are you talking about? I thought you were studying law. Okay, good. Well, law cuts across all levels of life, doesn't it? All right, so that's undue influence, everybody. Must know. By the way, what I have noticed in students studying undue influence questions is they forget to say what effect undue influence has on a contract. Undue influence renders a contract voidable. And make sure you know what voidable means. The innocent party has an option. They can void the contract, or they take no action, the contract carries on. Now make sure you know the difference between rendering a contract voidable and rendering it void. The contract is rendered void, it's void automatically, without any action of the parties. It's void automatically. All right, and then what else we got? Don't worry about that. Don't worry about that. Remedies for undue influence, yes. Interesting. One one good quote, everybody, that undue influence is in equity. The court is operating as equitable jurisdiction. When it comes to equitable remedies, here's a good quote for you. The court will mould the relief to give effect to the equity. Mould the relief, M-O-U-L-D, mould the relief to give effect to the equity. It's up to the court on the facts of each case. Okay? So this is a new PowerPoint, I think, because some students, I don't know, you could get rescission, but difficult. And so it's really up to the court. And in equity, the courts will mould the relief to give effect to the equity. In other words, equitable remedies are very wide-ranging, very flexible, as opposed to remedies at law, which are very narrow. The only remedy at law is damages. But with remedies in equity, can range from an injunction, specific performance, damages, could be anything. Illegality, forget. Unconscionability, though, make sure you know the UCO. Is there a definition of unconscionability? No. Criticise the UCO because it only covers contracts for sale of goods and supply of services. A lot of people think it should have covered contracts relating to land, but it doesn't. There's no definition of unconscionable, but the courts will look at various factors, including, look at this, undue influence. But mainly the strength of the bargaining positions of the parties. That's the key point, okay? And then Section 5, the courts can come up with basically anything they think is worthwhile. And so the remedies are very flexible for unconscionability. So do you need to remember the section numbers? If you can, 3, 6, and 5. If you can't, doesn't matter. Just say the court will look at various factors, come up with a remedy which will suit the facts of each case. But remember, the UCO only covers contracts for sale of goods and provision of services. Must know the Hansen credit card case. We've been through the facts before. A customer owed, don't quote me on the numbers, but something like $20,000, but the legal expenses were much greater. He wasn't happy, went along to the Consumer Council, then go to the Court of First Instance. Mr. Justice Yam held that the clause requiring the customer to pay legal costs at the highest indemnity rate was unconscionable. Why? Well, number one, there was certainly unequal bargaining power. Number two, the interest rate was certainly high, but not extortionately high. The main reason was the question of costs is not for the parties, it's for the courts to decide. The court has total power when it comes to deciding who pays costs and how much. So that was the critical point in the Hansen credit card case. Okay? So the main reason was that costs are at the court's discretion only. So if you look at your credit card agreement with your magnifying glass later, you'll notice the clause dealing with costs has been amended. Interesting, and this again is a criticism of the UCO, why is the burden of proof on the consumer? But Section 5.2 does say that. All right? So the UCO looks good, but it's restricted to contracts for sale of goods, provision of services. It does put the burden of proof on the customer. And very few cases on it, but the Hansen credit card case is a good one. Okay. Unconscionability at common law, I doubt you'll get a question on this in the exam, but there is this case, fairly recent case, Chang and the Bank of Singapore, in which a very, I like this word, simple couple inherited a lot of money, went along to the bank. Can you advise us on how to invest our property? They lost a lot of money, and the court found there was total inequality of bargaining power. The bank had all the power, the couple didn't know anything, and so they found that this was unconscionable. But it was not a contract for sale of goods or provision of services. It was something dealing with land, I think. Unconscionability at common law, I think, should know, not must know. UCO must know. Okay. Although interestingly, the Low and Churn case, elderly sisters, it was a property developer. The property was divided into two. The sisters owned half, and somebody else owned the other half. The property developer had already sold this half for, I don't know, $2 million, but they sold the sisters' lot for only $800,000. And the court found that was unconscionable because the developer took advantage of their far superior bargaining power. And it was sort of dishonest, if you like. Good. So that's Vc18 Elements. Now on to termination. Four ways of terminating a contract. Termination by performance, should know. Termination by breach, must know. Termination by agreement, should know. Termination by frustration, must know. Okay? So I'm not going to focus too much on performance or agreement. Breach we need to look at briefly. But certainly we're going to focus on frustration. Frustrations definitely must know. Could get a question on frustration in either Part A or indeed Part B of your exam. There have been 40-mark questions set on frustration in past exam papers. Okay, so we'll go through them. So termination by performance, should know. Termination by breach, must know. Remember, this depends on whether it's breach of a condition or possibly an innominate term. Remember, what's an innominate term? The court will look at the effect of the breach, and if the innocent party is deprived of substantially the whole benefit, that will be treated as breach of a condition. If not, breach of a warranty. Should know that with regard to breach, there can be actual breach or anticipatory breach. Actual breach means time to perform your obligations has come, you don't perform, you're in actual breach. Anticipatory breach means you've got a contract already concluded, but one of the parties then comes to you and says, listen, I know we've got a contract, but I'm telling you now, I'm not going to perform my obligations. Are they in actual breach? Not yet, because the time hasn't come to perform. So this is anticipatory breach. Okay. Now, with actual breach, it's straightforward. The innocent party has to accept the breach, then the contract terminates. Until they accept the breach, the contract carries on. With regard to accepting the breach, there's no particular form of acceptance. You don't have to call them up or even send them a message. The court can actually look at the conduct of the parties and decide that the breach has been accepted. That's the Santa Clara case. Okay, but of course it's wise to send a message of some sort, particularly these days. It's so easy. Okay, an important point to note, of course, does breach terminate a contract? The answer is no. Acceptance of the breach terminates the contract. So this is why we call it repudiation and acceptance. And then with regard to the difference between actual and anticipatory breach on the screen, with regard to anticipatory breach, what can the innocent party do? Well, you'd think they could accept the breach straight away, terminate the contract, claim damages, but you don't have to. Why wouldn't you? Well, because if you terminate the contract straight away, you may get only nominal damages because you've suffered no loss. And damages are compensatory. They compensate parties for loss. Okay? And so an innocent party with an anticipatory breach can carry on performing their obligations under the contract. So that's White and Carter and McGregor, House of Lords case, which again is not in your course manual, should be, in which there was a contract between White and Carter counsel and McGregor, for McGregor to do a painting job for 2 years. He wasn't going to get paid until the end of the 2-year period. The council said, I know we've got a contract, but we're telling you now we're not going to pay you. So what did McGregor do? He kept on painting the rubbish bins for 2 years and then put in his bill. Could he do that? Well, the House of Lords said yes, you could, okay, because there's no duty, you don't have to accept the breach, and there is this principle of lessening your losses or mitigating your losses, but that only applies with there's actual breach. Okay? But there are limitations on White and Carter and McGregor. The court's saying, well, if you require the cooperation of the other party, then you've got to terminate. Also, you can't carry on performing your obligations in anticipatory breach unless it's reasonable. Okay. All right. Brace and Calder is a good example of mitigating your loss. Brace and Calder, somebody was employed by a partnership on certain employment terms. The partnership got rearranged, so technically he lost his job, but he was offered exactly the same job on exactly the same terms with the new partnership. He should have accepted it. He should have mitigated his loss. Okay. So what's on the screen, everybody? Should know, bordering on must know. You could get a question on the exam on, termination of a contract by breach. Termination by agreement, don't worry about. Termination by frustration, must know. And you must know the definition of frustration. Frustration occurs when, without fault of either party, performance of a contractual obligation has become either impossible, illegal, or radically different from that which was undertaken by the contract. I've got Lord Radcliffe in Davis Contractors and Ferrum, and yes, House of Lords must know. Lord Radcliffe actually only gave us the radically different bit, but you can combine it with the other situation in which you have frustration. Obviously, impossible is impossible, illegal is illegal. So frustration is raised when? As a defense. Frustration is raised as a defense. To what? Look at the definition. You are charged with what? Breach of contract. So you raise frustration as what? A defense to breach of contract. Make sure you know where it fits in. It's a little bit like an exemption clause, not exactly the same clause. An exemption clause is raised as a defense to what? A claim for either breach, misrepresentation, or negligence. Frustration is raised as a defense, but only to a claim for breach of contract. You are not performing your obligations under the contract, you're in breach. They say, yeah, I'm not performing because it's now impossible. Or the law's changed, it's now illegal. Or the nature of the contract has become radically different. Okay? So know the definition of frustration. Know where it fits in. It's a defense to a claim for breach of contract. Okay? And know what the effect of frustration is on a contract. It renders a contract void automatically. From when? The date of the frustrating event. Must know, must know. It's a very drastic result. The contract is rendered void automatically from the date of the frustrating event. Okay, so what's on the screen? Everybody must know, must know, must know. Must know the definition, but must understand what it means, and therefore you know where frustration fits in. It's raised as a defense. Okay, good. Now, because of the drastic effects of frustration, the courts are reluctant to find there's frustration. That's Davis Contractors and Ferrum, where the price of materials went up 40%, but the court said that's not frustration. You've just made a bad bargain. Okay. Also, there could be provision in a contract covering this particular event, such as bad weather, strikes, wars, or whatever. Okay. And if there is provision in the contract covering the event, you follow what's in the contract. Okay. Also, with regard to frustration, everybody, whether or not there's frustration, it's a question of the common law. Apply your definition. But the effects of frustration, the remedies, are in legislation. Section 16 LARCO must know. So you can draw a parallel between frustration and misrepresentation. Misrepresentation, whether there's misrepresentation or not, apply the definition. Common law, if you like. But the effects of misrepresentation, the remedies, are in legislation, the misrep ordinance. Okay? Similarly here, with regard to frustration, is there frustration? Apply your definition. It's a question of the common law, but with the effects are in legislation, section 16, LARCO. Okay? So good PowerPoint, this one. This is quite good. All my PowerPoints are good. No such thing as a perfect PowerPoint, but pretty good. Okay. And I'm always working on them, by the way. I say, hang on, well, maybe I can do this a little bit better. Maybe and if there's any contradiction between my PowerPoints and your course manual, follow my PowerPoints. Okay, examples of frustrating events. Now let's go through the must-know cases on frustration. Draw up your list. First one, Davis and Theron, which gives us the definition of House of Lords. Must-know Davis. Number 2 case, must-know on frustration. Taylor and Caldwell, because you could get a situation where the subject matter is totally destroyed. That's frustration. Where the subject matter is unavailable, good. These are the performing concert type cases. Condor and Baronites. Baronites was a pop group, and their drummer got ill, couldn't perform, and they couldn't get a replacement drummer in time because apparently it's very difficult for them to play certain numbers because I'm not a musician, but apparently. So that actually was frustration in Condor and Baronites. The drummer got ill, and they couldn't find a replacement drummer in time. Gomurko is a must-know case. We'll come to that in a moment. Gomurko is must-know. Okay. The other cases should know, except Crellin Henry, Contrast, Herne Bay and Hutton. Crellin, these 2 cases, the bottom 2 cases, are must-know because they focus on what do you mean by radically different. In Crellin Henry, pretty well set out in your course manual, so course manual's good on this. A new king was being crowned, and so somebody hired, it wasn't a hotel, they hired some property which overlooked the route of the procession, the coronation procession. Okay. But then the king got ill. Actually, everybody thinks he got ill because he was a drinker. But anyway, he got ill, so the procession was cancelled. And so the person who hired the room had paid a deposit, but then they refused to pay the rest. So the hotel or whatever it was sued them for breach of contract. But the person who hired the room says, no, 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 frustration. Frustration occurs when? Without fault of either party. Well, neither party was at fault that the procession was cancelled. Their contractual obligation became impossible, not impossible. Illegal, not illegal. Radically different. Well, the defendant did argue radically different and succeeded. What do you mean by radically different? It goes to the roots of the contract. And the court agreed. The whole purpose of the contract in Crellin Henry, the House of Lords finally agreed, was to view the coronation possession. But everybody scratches their head on this, and by the way, Crellin Henry was a 3-2 decision, so 2 of the judges disagreed in the House of Lords. Because when you hire a room, it's not just to look out the window. There's a washroom, you've got seats you can sit on, are there other things there? So everybody thinks Crellin Henry, the defendant, was very, very lucky. By contrast, Herne Bay and Hutton, a contract to sail around the harbour, and view the naval display put on because of the coronation again. Both these cases were decided at the same time. but the naval display was cancelled because the king got ill, and so the person who hired the boat pleaded frustration because they were sued for breach of contract because they refused to pay for hiring the boat. But the court said, no, this is different. What did you start off with? A contract to sail around the harbour and view the naval display. What did you end up with? A contract to sail around the harbour. Different, yes. Radically different, no. So Herne Bay and Hutton, the claim for frustration did not succeed. Okay? But there's not a great deal of difference between these two cases. All right? Everybody thinks, though, the defendant in Krill and Henry was the lucky one. They were able to prove to the court that the whole purpose of the contract was view the coronation procession. Now, you also have to appreciate it's early 20th century. Now, the Brits are pretty keen on their royals at the moment, aren't they? I mean, look at Prince Philip's death. The BBC's been criticised for having blanket coverage of his death, 24 hours a day. Here, Prince Philip here, Prince Philip there. Oh, wasn't he lovely? 110,000 complaints to the BBC because they're not showing anything else except Prince Philip. But can you imagine the early 20th century? The Brits are even keener on their kings. Of course, the court said, of course you wouldn't hire a room just to view our lovely king. And I'm a Republican. But I mean, everybody's interested in the royals. I bet everybody's looked up, will Harry have a good meeting back with William when he flies back to the funeral? Meghan's not attending because she's pregnant, can't fly, so they say, well. So you've got to put it in context, okay? Krill and Henry, coronation procession. Herne Bay and Hutton, though, seems a much more sensible decision. Okay? All right, so enough. But watch out for Krill and Henry, Herne Bay and Hutton. Questions have been based on these two cases. Largely Herne Bay and Hutton. Okay, somebody hires a boat to go around Hong Kong Harbour and view the fireworks. But then the fireworks are cancelled because of the weather. So it's Herne Bay and Hutton. Okay? Frustration. So if you know the facts of Herne Bay and Hutton in particular, could be very useful because you could get a question in the exam with similar facts. Okay. All right. So must know Davis and Farrer, must know Taylor and Caldwell, must know Gomurko, must know Krill and Henry, must know Herne Bay and Hutton. Okay, now with regard to Gomurko, Gomurko interprets section 16 sub 2 of LACO. Remember, the idea with the legislation was to try to achieve some balance between the parties. Before the legislation, the law was pretty tough. Losses lie where they fall. So if you spent a lot of money on the contract, bad luck, you lost out. So it was very unfair. So that's why legislation was enacted in England, very similar in Hong Kong. So section 16 sub 2 tries to achieve a better balance with regard to the effects of frustration. So under section 2, all sums paid, a deposit that is, will be recoverable, and any sums payable will cease to be payable. However, with regard to the deposit, the court can deduct from the deposit expenses incurred by the other party. It's totally up to the discretion of the judge in a particular case. Okay, so let's have a look at Gomurko first. Where's Gomurko? Gomurko must know. There have been questions based on Gomurko in past exam questions. In past exam papers. You've got the facts there. It was a rock concert. There was a frustrating event because the venue involved was deemed to be unsafe without fault of either parties, and no other venue could be found in time. So it was impossible to perform. So Gomurko is a good example of a frustrating event. But then, question was, what about the effects of frustration? Well, a deposit was paid, quite a heavy deposit on account £412,000. And so under section 16 sub 2, the deposit could be repaid, but the court could have deducted anything up to £50,000 because that's with the expenses of the other party. But on the facts of the case, the court decided to refund the deposit in full, no deduction. The court could have said, all right, deposit refunded, but less £10,000, £20,000, £30,000, $40,000, up to £50,000, but they decided, in their wisdom, to deduct nothing from the deposit. Probably because the plaintiff had incurred far greater expenses than the defendant, $450,000 compared to $50,000. Okay? But Gamerco is a good case because it's the only real case on the operation of section 16 sub 2. Okay? All right, so Gamerco is the case on section 16 sub 2. Watch out in exam questions, you have to note, has a deposit been paid or not? Okay? And if there is, section 16 sub 2 applies. Also, the court can award what we call a just sum for any valuable benefit conferred on the other party under section 16 sub 3. However, the law here is not very satisfactory. There's only one case, BP and Hunt, and it's only the first instance decision, even though BP and Hunt went to the House of Lords on other issues. BP and Hunt's interesting because it was a good example of a frustrating event, because in Libya, Colonel Gaddafi nationalised the oil industry, kicked out the Brits. So was that frustration? Yes. Without fault of either party, the oil industry was nationalised. So if you like, there was illegality because it was illegal for BP to operate in Libya anymore. So what about the effects of frustration? Well, there's no deposit paid, but the court did award a just sum for the oil that had been extracted from the ground, and the net sum is $35 million US. Okay? So BP and Hunt is an example of the application of section 16 sub 3. Okay? All right, so BP and Hunt must know. So with regard to frustration, must know Davis, must know Taylor and Caldwell, must know Crellin Henry, Kernbay and Hutton, must know Gamerco, must know BP and Hunt. How many is that? About 7? You've got it. With those 7-ish cases, you'll cover any question on frustration. Oh, perhaps there's one point that perhaps we should go through, yes. Having said that, self-induced frustration. Self-induced frustration is not frustration. Why not? Because one party's at fault. And Maritime National Fisheries, your must-know case, 5 ships, only 3 licenses, so a deliberate decision was made to deprive 2 of the ships of a license. The court said that's not frustration because it was an intentional act to deprive 2 of the ships of a license. Okay? So Joseph Constantine Steamship Company is an interesting one too, where the court looks at what do you mean by fault? There's a whole range of fault. Fault can be, down the lower end, right up to an intentional act. And it's very difficult to prove fault. So anyway, that's one of the limitations on the scope of frustration. Okay? Right, so that's frustration, and that's termination of contract, and that's just about termination for us. We haven't covered remedies. We'll cover remedies very quickly next time we meet on Saturday. But the main remedy for breach of contract damages, that's pretty well it, you need to know. But with regard to the must-know bit on remedies, well, liquidated damages clauses, I'd suggest, is worth remembering. What's a liquidated damages clause? It's a term in a contract which says how much money the innocent party will get when there's breach. Courts love a liquidated damages clause because they don't have to get involved in complex calculations. The problem is a liquidated damages clause cannot be in the form of a penalty. It must be a genuine pre-estimate of loss, because the main aim of damages is compensation. It's not punishment to the guilty party. Okay, so we'll go through that when we meet again on Saturday. Also, we'll deal with the specific equitable remedies of specific performance and an injunction. The remedies in equity can come up in Part A of the exam, so we'll go through that, but we've got time to do it on Saturday, because on Saturday we'll be covering the tort part of the course as well, and the tort part of the course is slightly shorter than the contract part of the course. Okay, everybody, well, great seeing you all again in person. Thank you for your attention. Anybody, any final questions, queries, worries, anxieties, comments, suggestions? You know my suggestions. Must know definitions, must know principles, must know cases, and then you're in good shape for the exam. Okay, so we'll finish off remedies when we meet again on Saturday, and then we'll cover the tort part of the course, negligence and nuisance. Okay, so my suggestion is check through your notes, see if you've got any questions.